Hello class, once again it's me, your instructor, for another video recording about our subject. So before we start, again please be reminded, if you have a question, please don't be shy to have it in our comment section, or if not, please raise it when we are going to have our synchronous session so that we can discuss it as a class. And another one, if you have your e-copies of your learning module, or if not, the printed, if you printed it out, so as you go on with this video recording, kindly please refer also to your learning module as we go on with this video recording. So that's it. I do hope that everyone is doing fine still, and then kindly please watch this video until the end so that you won't miss any information that might come out in your quizzes, or if not, in your exams. So that's it. Thank you very much. We'll now start with our lesson. To start with our video recording for today, let's talk first about dispute resolution. So we have here the so-called dispute resolution. So in other words, it is termed as dispute settlement, or if not, conflict resolution. So those three are just the same actually. Okay, so dispute settlement, or it could also be dispute resolution, or it could also be termed as conflict resolution. So they are just the same. And then we have here its definition. It says here, it is the process of resolving disputes between parties, or process of resolving conflicts between parties, okay, or process of solving claims between parties. So that is just the simple definition that we can give there. Okay, so we are not going to make it as complicated. So we have here another explanation about that. It says there, it assists the resolution of antagonisms between parties. So there, parties doesn't only mean a single person between another person. Okay, so it could be, we have the so-called natural person, sorry for that, the natural person against a certain juridical person. So ano yung tinutukoy natin na juridical person? So it simply refers to an organization. Okay, so don't forget, juridical persons are those companies or organizations, or it refers to a group of persons. Okay, and then there, it could also exist between a certain organization, between another organization, or in other words, a certain juridical person and another juridical person, or if not, a natural person between another natural person. Okay, so that is all about dispute resolution. So just simply don't forget, it is the process actually of resolving conflicts or disputes between parties. By the word itself, dispute resolution. Okay, so next we have here the methods of dispute resolution. So what are those? So first, there is the so-called lawsuit. So what is lawsuit? So it is simply the proceeding by a party or parties against another in a court of law. So take note of the word court of law. So it could be in a civil proceeding or in a court of law, and criminal court of law. Okay, so it does not only refers to a certain civil court of law, but actually or usually kasi nagagamit ang terminology na lawsuit in civil proceedings, but actually it can also be used as terminology in criminal procedure, or in criminal cases or criminal courts. So ano ba yung tinutukoy nito? So in other words, it simply refers to the case being filed in court or before a court. So in lawsuit, you are not availing the so-called ADR. Okay, so it is not actually it is out of the topic about ADR. So sa lawsuit, hahayaan mo na yung magsosolve ng dispute or ng claim mo is yung korte mismo. Okay, so that is simply about lawsuit. So you are letting the court or the judge or the court as a whole to solve the disputes or to solve your claim. Okay, so that is simply means by lawsuit. And then in lawsuit, don't forget, in the courts, don't forget the terminologies of the parties. So we have the plaintiff or the claimant, and then we have the defendant or respondent that are being used. So don't be confused with that. So usually in lawsuit, plaintiff or the claimant, usually they are the ones who demand a legal or equitable remedy. So yun, sila mismo yung kunwari, we have here Mr. Iskaran. Gusto niyang makuha yung lupa kasi sinasabi niya, lupa ko yun, pero bakit pinatayuan ng bahay ni Mr. X? So yun, Mr. X, gusto ko siyang umalis doon sa bahay, sa lupa kong yun, kasi yun ay nakapangalan sa akin. Actually, meron po akong titulo ng lupa. Okay? Nakapangalan po yun sa akin. Binigay po yun ng aking mayamang ama or yumaong ama. Okay? So that is yung claim niya. And then we have another one. Usually, ang role naman ng defendant or ng respondent is to answer the claim of Mr. Iskaran. So, let's say, I am Mr. X, hindi po totoo yung sinasabi ni Mr. Iskaran. Kasi sa totoo lamang po, ito po ay minana ko sa aking magulang. Okay, so yun yung reply ni Mr. X. So, that continues now or the dispute exist. Okay, so what will happen now? In lawsuit, we have the so-called litigation. Okay, so simply litigation, it refers to the criminal or civil procedure. So ano yun? It's simply yung nangyayari doon sa loob ng korte. So actually, the so-called lawsuit, yun yung kabuuan. Okay, the whole from the initiation, okay, up to the end. Okay, yun yung kabuuan or a broader term as described, yung lawsuit. Pero yung litigation, ito yung sinasabi natin na again, criminal or civil procedure. Ito yung proseso, yung nangyayari doon sa loob ng korte. Okay, lawsuit or the conduct of lawsuit, in other words or in other definition. So yun, in criminal procedure, if you remember the so-called, what are the steps or the procedure there? First one, we have the so-called arraignment. Okay, so in arraignment, if you forgot, to remind you, in arraignment, that is the time wherein the accused or yung nasasakdal ay tatanungin ng judges. Tatanungin sa court of public. Okay, so ibabasa sa kanya yung complaint. In criminal procedure, ibabasa sa kanya yung complaint, and then tatanungin siya if he is guilty or not guilty. So if he plead guilty, then that's the time or that's the time or next there to happen the case will be dismissed. Kasi umamin siya or the accused will be convicted immediately after a certain sort of investigation. So yun, na patunayan voluntary yung pag-amin niya, then that's the time mako-convict siya agad. Okay, however, if he says not guilty, your honor, not guilty, your honor, sabi niya, so meaning the litigation will still continue. Okay, so anong susunod doon? After the arraignment, it will now proceed to the pre-trial. Okay, and then after pre-trial, we have the so-called trial, and then we have now the judgment. However, if the person is not satisfied with the judgment that was given, then that's the time we have another process, the so-called appeal. Okay, that is in criminal procedure. However, in civil procedure, we have the so-called, arraignment usually doesn't exist in civil procedure. It doesn't exist in civil procedure. Because in civil procedure, they are just going to summon the person. So, there is the claim. So, meron na yung claim ng tao or yung sinasabi niya na yung gusto niyang mangyari. Okay? So, demand niya. So, that's the time sasabihin ng judge or titignan ng judge, and then ang gagawin niya, he will issue a summon. Okay? Or the subpoena ad testificandum and subpoena ducesticum. Or in other words, the judicial order, the COC that was being used in other courts, or judicial order as a judicial order in simple terms. So yun, ang gagawin doon is isusumon yung tao, okay, yung respondent. So if the respondent has his reply, okay, nag-reply siya and then sinasabi niya, hindi po totoo yung sinasabi ng taong yan. Okay, and then yun yung reply niya. So the litigation will follow. Pupunta na rin sa pre-trial, parang sa criminal procedure. So, yun nga lang, hindi arraignment yung tawag nila doon. So, yun, meron siyang reply. However, paano kaya kapag walang reply? Hindi pinapansin nung respondent yung claim nung tao. So, that's the time, then the judge or the court can just decide, yun, the award or the decision will be in favor of the claimant. So, yun, ipapatupad na yung claim nung tao, kunwari sa lupa. So, yun, paalisin na si Mr. X doon sa lupa na yun. Kasi hindi niya, parang winave niya yung right niya to answer or to defend himself. Okay? So, that could be the circumstance that will exist in times na hindi mo papansinin pag merong reklamong dumarating sa'yo. Okay? So, make sure that if there is a claim that was being filed against you, then don't waive your right to reply. Okay, you answer, you defend yourself, especially if you believe that you are the right one. Okay, so that is for litigation. So take note, litigation is simply refers to the criminal or civil procedure, or the procedure that is happening inside the court actually. So yun, we have also here, again, be reminded, in court, in litigation, tinatawag nila na litigants. Usually, sino yung mga litigants? Yung mga tao na involved or the parties involved in court. So, it can be the plaintiffs and then the defendants. And then, we have the litigators na tinatawag nila, the attorneys. Okay? Litigators, attorneys, yung tawag nila doon. Okay? So, don't forget that. So, I hope that you keep those in mind. Next, we are going to talk about arbitration. So, mind you, arbitration is already under the so-called ADR, or the so-called alternative dispute resolution. Or in other words, they call it as appropriate dispute resolution. Okay, so now, let us try to define and discuss this one by one. Arbitration na ito. So, it says here, the dispute will be decided by one or more persons, or yung tinatawag natin na arbiter or arbitrators, or kung hindi man, the so-called arbitral tribunal. So, yun, as mentioned, pwedeng iisang tao yung mag-decide mismo, or pwede rin na group of persons, or yung arbitral tribunal na sinasabi nila. Okay, so yun, the arbiters or arbitral tribunal, or these arbitrators, they are the ones who can render the arbitration award. So, ano yung arbitration award na sinasabi natin? So, yung arbitration award po na yan, simply yan yung parang sintensya kung sa court proceeding. Okay? The sentence or the judgment. So, ito yung decision. Simply, decision is the arbitral award. Pero yon sa terminology ng sa arbitration, ginagamit natin is the arbitration award, or yung decision ng arbiters or arbitral tribunal. So, in arbitration, it can be used whether in commercial disputes or employment. Okay, so to further explain about arbitration, I have here a guest. So, meron akong bisita dito. Gamitin natin sila as an example. Okay, so I have here the first visitor. Meron tayo dito si Bumblebee. Okay. So, we have here Bumblebee. So, si Bumblebee, sabihin natin siya yung claimant. So, sabihin natin din na si Bumblebee, siya ay, para lapit natin para makita nyo. So, ito si Bumblebee. So, yun. Si Bumblebee, sabihin natin siya ay balikbayan. So, nanggaling siya sa abroad. Sabihin natin siya ay mag-isa na lang sa kanyang pamilya, or mag-isa na lang siya na nabubuhay, wala na siyang pamilya. So yun, nag-abroad siya for 5 years. So after 5 years, bumalik siya ng Pilipinas, particularly here in Cavite. So yun, pagbalik niya dun sa property niya, iniwan niya, merong nang nakatira. Okay, sabihin natin, nandito naman sabihin natin ito si Superman. Okay, so take note, Superman. Okay, so si Superman, yun, pagbalik ni Bumblebee sa Pilipinas, pumunta siya dun sa lupa na balak niya sanang tayuan ng bahay niya. Kasi alam niya, meron siyang iniwan na lupa na namana niya sa parents niya. Nung siya ay nag-abroad, iniwan niya yung lupa. And now, after 5 years, bumalik siya, nakita niya si Mr. ay ito si Superman. but meron nakatayong bahay. Meron siyang nakatayong bahay doon sa property ni Mr. ay sabihin natin si Bumblebee. Nalilito tuloy ako. Okay, so yun na. Ganun yun yung claim. Ito yung claim ni ito yung paniniwala ni Bumblebee. Okay, so yun yung issue. And now, kinausap ni Bumblebee itong si Superman. Bakit ka nandito? Akin to. Sabi niya. Okay, sabi naman ni Superman, anong sa iyo to? Matagal nang walang nakatira dito. Matagal na rin nakatayo yung bahay kong to. Okay, so yun yung claim niya. So ayaw niyang magpabigay. Pero yun, desperado si Bumblebee na makuha yung property niya kasi alam niya yun ay pinamana sa kanya ng parents niya. Okay, so yun, tuloy-tuloy siya nakikipag-negotiate. Yun, pinapalayas niya pero matigas itong si Superman. Okay, so this time kinausap niya ulit. So kung kinausap niya. So since ayaw ni Bumblebee na gumastos, okay, kasi alam niya mas magastos kapag sa korte nila dadalhin yung case nila. And then ito naman si Superman, ayaw niya din gumastos ng masyadong napakalaki. So yun, they agree to go into an arbitration. Okay, so ngayon nakapag-decide na sila, sige, we are going to undergo arbitration. Yun, sabi niya, nag-agree sila. And that's the time, pipili sila ng tao, ng arbiter nila. Okay, so, yun, meron silang napili na arbiter nila. So, nandito sabihin natin si Sheriff. Okay, si Sheriff. Okay, so, yun, Sheriff will now act as their arbiter. Okay, so anong kaya niya, Lapit natin para makita nyo. So, to explain further, si arbiter, kaya niyang si arbiter, he has the power to decide between these two. Okay, magbigay ng decision. So, yun, meron siyang kakayahang magbigay ng arbitration award. Okay, so yung claim ni, so ang gagawin niya pala, he can demand the certain group to present evidences about their claims or present proof about their claims. So ito, sabihin natin si Bumblebee, sinasabi niya meron siyang titulo. Okay, present niya kay arbiter. And then ito naman si Superman, wala siyang ma-present na titulo. Okay, so sabi niya lang it's because of yun, matagal na siyang nandun. Okay, walang nakatira doon sa lupa na yun, and then yun, pinatayuan ko na lang ng bahay. So yun, matagal na ako doon, and then I consider it as my property already. Yun yung claim niya. Okay, so this time, klarong-klaro kay Mr. Sheriff niya. So nagbasehan niya, mas pinaniwalaan niya si Bumblebee. So yun, he can now decide. Okay, he can now give arbitration award. So ibibigay na yung arbitration award kay Bumblebee kasi siya yung mas may clear and convincing yung proof niya. Okay, so anong mangyayari kay Superman? So ang gagawin ang sasabihin ni arbiter, now that yung natin or yung decision natin ay in favor of Bumblebee, so kailangan mo nang umalis dyan sa property na yan kasi yan ay property we believe that or we have decided already that the property belongs to Bumblebee, hindi sa'yo. So yun, kailangan nang umalis ni Superman. However, sabi ni Superman, hindi, I do not accept that decision. Sabi niya, so anong gagawin ni arbiter? Or anong gagawin ng tong dalawa? This time, papasok na dyan yung korte. Okay, and then the court will now enforce the decision of the arbiter or the arbitral award. Okay, the court can enforce that. So yun, magmatigas ka pa rin, then pwede ka nang makulong kung ayaw mong sundin or irespeto yung decision. So you could be filed with a fine or not, you could be imprisoned. Okay, so yun yung sa arbitration. Okay, or yung simple example of arbitration. So don't forget also, arbitration award simply refers to the decision. Okay, and next we have here another one. Tingnan pa natin, ano pa bang meron dyan? We have the so-called mandatory arbitration and then consensual arbitration. So, let's take another example for that. So, sabihin natin si Superman, isa siyang businessman. Okay, businessman. So, meron siyang kumpanya, pangalanan natin, Superman Company. Okay, so yun yung pangalan niya. Okay, or sabihin natin, Superman Multi-Millionaire Company. So, yun yung company niya. And then, we have the other one. Meron din ito, si Bumblebee, a businessman. Okay, a businessman also. So, yun. Pangalanan natin yung company niya, Bumblebee Multi-Millionaire Company. So, yun. They decided, sabihin natin, they decided to maging magkasosyo, to become business partners. So, they decided to become business partners. So, with that, usually, in order to have formality with that, okay, to secure their rights or to ensure that their partnership is in legal or sabihin natin formal, lumalabas na dyan yung contract usually. Contract, okay, memorandum of agreement or a contract, sabihin natin. So, yun. And then, let's say in the future, sabihin natin, in the future, nag-away itong dalawa. Okay, ayaw ko nang
business partner sa'yo. Tangina mo, nilulogi.
Ganun yung sabi ni Bumblebee. Kaya ito sumagot naman si Superman. Sabi niya, wala na rin akong pakialam sa'yo. Putang ina mo. Ayaw din kitang maging putang ina mo.
Ayaw din kitang maging business partner na. Okay, parang yun yung sagutan nila. Okay, so yun. Sabihin natin, to explain mandatory arbitration, sabihin natin, magiging basihan dyan kasi yung kontrata nila. Okay, so the statute or statute or agreement from a contract. Sabihin natin, doon sa kontrata na pinirmahan nila nung una, nilagay nila na if we are going to, parang sinabi doon, if a conflict exists in the future or dispute exists in the future, two of us or the parties or each of us will undergo mandatory arbitration. So, nakalagay dun sa kontrata nila. So, yun, under mandatory arbitration, they will mandatorily have the so-called or avail mandatory arbitration. Okay? So, hindi na nila i-avail yung ibang proseso or ibang dispute resolution. So, they will not be bringing it up already in courts. Okay? Kailangan they should undergo first mandatory arbitration kasi yun yung nandun sa kontrata nila. How about consensual arbitration? So, in this, ito na lang naman is parang voluntary. Okay? So, wala sa kontrata. So, meaning they can decide. So, Bumblebee, gusto mo bang mag-undergo ng arbitration? Okay? Would you like our dispute to be solved under arbitration or not? So, yun. And then, Superman will also decide. Okay? So, yun, consensual. So, if they agree between each other, then that is so-called consensual arbitration. So, yan. They should just take note, in consensual, there should be confirmation between parties. In mandatory arbitration, it is usually coming from a statute or comes from the contract that they have agreed upon in the beginning. Okay, in the first place. So, that is an example of mandatory and consensual arbitration. I hope that that is clear. And then the next one, we have also here the so-called binding and then binding arbitration. So, simple lang naman po yung sinasabi dyan sa binding and non-binding arbitration. So, dyan sa binding, it is considered that the decision is already final. Okay? And then it can be also enforced by court. So, yun yung binding. And then, lastly, it can only be appealed on very narrow grounds. So, hindi basta-basta pong ina-appeal yan or yung decision, yung arbitration award na naibigay. Except only on a certain grounds, kung merong error, nagkaroon ng error dun sa part ng arbitrator. So, that could be appealable. In non-binding arbitration, so the decision cannot be imposed on parties except only when the decision is accepted by both parties. Okay, so yun, the arbitration award can be considered only as advisory. Okay, so hindi it is not final, in other words. So in binding, the decision is final. In non-binding, the decision is not final, in a sense, just to make a differentiate, those two. So just take note of that. So that is non-binding and then binding arbitration. So that's it for binding and non-binding arbitration. And next, we have here the advantages of arbitration that was mentioned by the PICCR. Okay, yung PICCR, pag-uusapan natin yan mamaya. An organization usually involves in arbitration. Okay, so next topic natin yan pag-uusapan. Pero yun, unahin muna natin yung mga advantages na sinabi nila. So, speed. In terms of speed. So, faster than court litigation. So, take note, in court proceedings, napakarami po or hectic yung schedule. What do I mean by hectic? So, parang once in a month ka lang makakapag-hearing niyan. Kasi, yun, napakaraming kaso na nakabinbin sa korte. So, paano yun? Scheduling yan. So, kung ngayon, this month, nagkaroon ka ng hearing. And then, expect na yung next hearing ng kaso or ng claim mo will be next month. Kasi napakaraming kaso. And then, another one, cost efficiency. So, balikan natin yung speed. So, in comparison with the court proceedings sa arbitration, simple. Hindi masyadong hindi masyadong napakaraming cases na sinusolve yung mga arbitrators. And then, yun, pwedeng mag-schedule kayo ng kanya-kanya yung or mag-schedule kayo ng parehas kayo na free. Okay, pwedeng sabihin niyo ngayon, pwede rin bukas mag-schedule kayo. Nasa sa inyo yung scheduling. Unlike in courts, usually scheduling it is in the decision of the court. Okay, or doon sa korte mismo. Hindi kayong yung pwedeng magsabi, magkakaroon tayo ng hearing ngayong araw na to, and then bukas. So, judge lang yung makakapagsabi or the court itself. And then we have here the second one, cost efficiency. So, aside from yun, kukuha ka ng napakaraming ng attorney na mag-represent ng evidences mo. So, yun. Aside from the attorney's fee na ibibigay mo, meron yung pampakape. So, kapag mag-meet kayo ng attorney mo, expect, you should carry on yung mga, sabihin natin, doon kayo sa coffee shop nag-meet. Hindi ikaw yung gagasto na naman para doon sa attorney mo. Okay, simpleng permahan lang. Bayad na naman yan. So, cost, mas magasto actually. Okay? Mas magasto aside from doon sa mga fees na babayaran mo doon sa korte. Okay, next one. Unlike in arbitration, you can just only simply mabilisan. So, hindi masyadong mapapadalas yung meetings ninyo ng attorney mo. Okay, so mas mabilis, mas cost efficient. Okay, so pero it depends actually on your lawyers. Baka iba-iba yung presyo kasi ng mga lawyers natin, iba yung mga rate nila. So it depends also. So next, flexibility. Parties are generally able to direct how the proceedings should be conducted. So yun nga, meron sa inyo, pwede kayong mag-decide. So okay lang ba? We can have another hearing or another session bukas. So yun, pwede kayong mag-set ng schedule, pwede kayong mag-usap kung saan venue, kung gusto nyo, dun sa kapihan, dun sa office ng isa sa inyo. Okay, so that is on flexibility. Another advantages, parties to participate in the choice of arbitrator. Okay, so yun, pwede kayong mamili ng kung sino yung magde-decide sa inyo. Unlike in courts, meron talagang specified or merong naka-assign talaga na judge para doon sa court na yun. Okay, and then finality, arbitral awards are generally not appealable on the merits. Okay, especially if it is a binding arbitration. And then we have here confidentiality, kasi take note, in court proceedings or court litigations, proceedings there are public. So, merong mga makakakita, makikinig. Let's say, ang pinag-aawayan nyo lang is 350 pesos na bag yung pinag-aawayan ninyo. And then yan, final nyo sa korte. Yun, pagtatawanan lang kayo ng public. So, yun, walang confidentiality. So, it's better if you are going to avail on arbitration. So, kayo lang. So, nandyan yung arbitrator or yung mga legal counsels ninyo. Kung nag-hire kayo ng legal counsels ninyo, then kayo-kayo lang mismo. And then enforceability, yung arbitral award na minimension natin, it can be enforced by court. So, yun, especially if it is mandatory or the so-called binding. Okay? Sana yun? Binding or not. Okay, so, yes, the mandatory arbitration. So, it can be enforced by the court or binding. I should say binding arbitration. So, that's it. Enforceability. So, those are the advantages of arbitration as mentioned by the PICCR. So please don't forget those informations about arbitration. Next, we are going to talk about collaborative law. So in collaborative law naman, it is simply on cases of divorce or family issues. So, yun, it is considered as legal process for couples actually. Okay, married couples. So, ano ba yung nangyayari dyan? So, in collaborative law, they work with their collaborative professionals or yung mga attorneys nila, including collaboratively trained lawyers, coaches, and financial professionals. So, it is simply considered also as win-win strategy. So, to further explain that, let us use this as an example. So, I have here Mr. I should say King of Hearts. Okay, so nandito si King of Hearts and then Queen of Hearts. So Queen of Hearts and King of Hearts, they decided to have a divorce. So yun, problema, meron silang anak. So anong mangyayari sa anak natin? Ganino mapupunta? Gusto ko mapunta sa akin. And then sabi naman ito, gusto ko mapunta sa akin. So yun, hindi sila mag-agree, hindi sila magkasundo sa negotiation. So they can now think of another or they have think another way in order to solve their dispute or their conflict. So with that, they choose to just have collaborative law because they don't want to give it or to let the court get in on their issues kasi it will be publicized or it will be taken in public. And another one, it's more expensive actually. So yun, it is also not speedy. So they choose to have collaborative law. So in collaborative law, the parties involved are here, King of Hearts and then Queen of Hearts. And then dyan na papasok yung sinasabi nila na trained professionals nila. Okay, so we have the first one. Sabihin natin si King of Hearts, nag-hire siya ng lawyer niya. So si Ace. Okay, Ace, and then si ano naman, si Queen of Hearts, nag-hire din siya ng lawyer niya. Okay. So yan, nasa na ba si King of Hearts? Wala. Si Ace of Speed lang yung available, kaya siya yung hinire niya. Okay, so they have their lawyers already. So they have their lawyers. So take note, the main parties there is King of Hearts and Queen of Hearts. Sila yung mag-asawa na magdi-divorce, and then yung attorneys nila, Ace of Speed for Ace of Speed for Queen of Hearts, and then for King of Hearts, the so-called it will be Ace of Hearts. So yun, and then there, sila mismo yung mag-usap-usap. So ano ba yung dapat nating gawin para win-win strategy? Kasi win-win strategy yung gusto ko. So gusto ko yung yung hindi ako masyado, gusto ko yung medyo pabor din sa akin, and then of course pabor din sa kanyang asawa. Okay, so yun, meron yung dalawa na to para tutulong i-solve yung conflicts. Kasi yun nga, in negotiation, hindi nila kayang dalawang ayusin. So with that, meron na namang under collaborative law, meron pan another trained professionals na meron dyan. So in order to solve yung mga natin in terms of pera, kasi usually in couples, married couples, kapag mag-separate yan, meron yung mga properties or meron yung mga financial issues na kailangan nilang i-solve, especially doon sa support ng bata. So with that, in order to solve that or to give advice, meron tayo yung sinasabi nila na trained professionals or financial professional. So, or financial expert. Sabihin natin yung financial expert na na-hire nila is si Jack. Okay, so Jack, ang role naman niya is financial expert. So siya yung magsasabi, siya yung magsasabi kung magkano kaya ang kailangan ibigay niya, no? Magkano ang kailangang ibigay ni sabihin natin ni King of Hearts kay Queen of Hearts para masuportahan yung anak nila. Okay, siya yung magdi-determine or yung division ng properties nila kung yung property na nabili nila is considered as conjugal. Okay? Conjugal property. So, meaning sila mismo yung bumili nun, gumasto nun. And there, as you can see in the picture, meron pang isang example, meron pang isang dyan. In order to maintain yung, sabihin natin, peace between the parties, parang coach, or in other words, give advice, okay, or recommendations that is in favor between those two, okay, or pabor sa kanilang dalawa, to give advices, nandyan sabihin natin yung advisor or yung mag-act as coach, sabihin natin si King of Diamond. Okay, so ilan yung parties na involved? So all in all, there are 6 involved in collaborative law. So parang negotiation lang siya, kaso meron ng professionals na involved. Okay, so nandyan 1, 2, 3, 4, 5, 6 participants or parties. So, yon, the party of King of Hearts and then party of Queen of Hearts with his legal advisor, Ace, and then another Ace as a legal advisor, and then the Jack as the financial expert, and then lastly the coach, King of Diamonds. So, that is simply to discuss to you collaborative law. Next, we are going to talk about mediation. So, under mediation naman, it is simply it is somewhat the same with arbitration. So, the only difference is that, let's try to go back on our example a while ago. So, for the example a while ago, we have here Superman and then Bumblebee, wherein Bumblebee has a claim that it is his property, and then also with Superman, he claimed that it is his own property. Okay, and then we have the arbiter, yung tinawag natin kanina na arbiter, si sheriff. Okay, so yun, let's try to have the example a while ago. So, in comparison with mediation, so ito hindi arbiter yung tawag natin under mediation already. So, usually in mediation, that could be also the barangay captain. So, usually, sa mga away doon sa isang bayan or isang barangay, usually it goes first on the barangay. So, usually na nagme-mediate dyan is the barangay chairman. Okay? So, let's say this is in mediation, let's say this is barangay chairman. Ito. Okay, he is the barangay chairman and he acts as the mediator. So, mediator actually yung tawag natin in the process of mediation. So, yun, and then we have the two parties. Okay? The claimant and then the respondent. So, yun, the only difference between arbitration and mediation is that the power of this third party. Okay, so yung power nung mediator. So, ano ba ang meron ang arbitrator na wala ang mediator? So, ang arbitrator, he has the power to decide, okay, or issue arbitral award. Question, how about the mediator? Does he have the power to give arbitral award or give decision? No. So, that is the only difference between mediation. So, walang power ang mediator na magbigay ng decision na kailangang sundin, na dapat sundin ng dalawang to. So, simply, he acts only as center to maintain peace or ma-ensure na walang pag-aaway na mangyayari doon or pagtatalo na mangyayari doon sa dalawa or peaceful yung proseso. So, yun lang yung role ng mediator. So, yun, pakikinggan yung dalawa. And then, he is usually neutral, okay, party-centered. So, participation and take note the similarities in comparison with arbitration. Mediation is also could be voluntary. So, sila mismo choice ng both parties, okay, if they will undergo mediation. So, yun. The mediator analyzes the issues and relevant norms, reality testing, sinasabi nila. The mediator refrain, yung mediator usually, he is not centered on a certain party. So, both party centered. Okay? So, the mediator actually doesn't have or avoid usually in saying, you should do this. You should do this. Ito ang kailangan mong gawin. No. He is usually there to recommend solutions that are in favor between those parties. So, hindi po biased to. So, the same with arbitrator. Arbitrators should be non-biased, as we have mentioned as you can see in the picture that was presented a while ago. So, meron yung characteristics ng isang arbitrator. Okay, or that will be presented later on. Okay, so non-biased. The mediator is non-biased. Should be. And then, ano pa bang kailangan nating idagdag dito? The process also is private and confidential, same as to the arbitration, kasi it is outside the court, and then the parties can decide when and where they can meet. Okay, so pwede kayong mag-decide there, saan tayo magkikita, kailan tayo magkikita. Okay, and yun. Mediation has structured timetable and dynamics that ordinary negotiation, or in negotiation kasi dadalawa lang parties, wala ito. Okay, so wala yung third party. So usually sa negotiation dalawa lang yung nag-aaway, nagtatalo na parties, pero in mediation, to structure or to organize yung resolution, meron dyan yung mediator. Okay, he could be the one, sabihin nito, free ako ng Monday, then sabihin naman ni Bumblebee, free ako ng Saturday and Monday. So, since free kayo ng Monday, then the mediator will fix a schedule on Monday. Parang ganun yung mangyayari. Organize yung negotiation nila. So, that is only the difference between mediation and then arbitration. So, it only relies on the power of the third party. Okay? So, don't be confused with that. Next one, we are going to talk on the conciliation. Sa conciliation naman, it is somewhat like also mediation in arbitration. But there, yun nga lang, kakaiba naman ito. Kasi same as there, sa conciliation, meron pa ring third party. Okay? Pero ano yung ginagawa ng third party? So, he meets up. So, ito ay to lower the tensions. Okay? Lower yung tensions, especially kapag mainit pa. So, yun, si sheriff. Ang gagawin niya, kasi mainit pa rin. Kapag nagkikita yung dalawa, mag-aaway-aaway sila. So, ang ginagawa ni sheriff, he will act as a conciliator. So, in arbitration, they call it as arbiter or arbitrator. And then, in conciliation, tinatawag naman natin na conciliator. In mediation, mediator. So, dito, conciliator. So, ang ginagawa ni conciliator, sabihin natin si sheriff, isang conciliator din. So, he meets up with, yun, laruin natin. He meets up with Superman. Okay, so yun, kakausapin niya si Superman. Ito, nagsabi na, and then, pagkatapos niyan, nakausap na niya, sinabi niya na yung gusto niyang mangyari. This time, aalis siya, and then pupuntahan naman niya si Bumblebee. Okay. So, yun yung mangyayari doon. Sasabihin niya kung ano yung papakinggan niya muna kung anong sasabihin ni Bumblebee, and then, i-explain din niya yung gusto niya, Pagkatapos ni Bumblebee, i-explain na yung sinabi ni Superman. Okay, so yun, parang siya yung nakikipag-meet up, parang liaison officer, in other words. Okay? So, ganun yung sa conciliator. Pero yung setup, the third party doesn't have the power to enforce or to give decision. Okay? Simply, encourage the parties to explore potential solutions. So, yun. You can, discover by letting them explain or sasabihin mo kung ano yung gusto ng bawat isa, and then unti-unti baka mamaya meron kayong ma-discover na better solution in order to solve that conflict. Okay, so yun yung part ng conciliator. So that is conciliation. So next, we are going to talk about negotiation. So as I've mentioned a while ago, in negotiation, it is only the dialogue between the two parties. So dito wala nang third party, wala nang pakialamero. Okay? So pag-uusap lang ito ng dalawa. So next, actually we are involved in this every day, di ba? Araw-araw involved tayo, nakikipag-negotiate tayo. So just an example with the allowance that was being given to you by your parents. Sabihin natin, ikaw at ng kapatid mo. Okay, so binigyan lang kayo ng tatay ninyo ng 1,000. So ano kayang pwede nyong maging paraan ninyo para ma-solve yung dispute ninyo? Nagtatalo kayo. Hindi, akin yan kuya, sabi nung kapatid mo. And then ikaw, hindi, akin lang to. Sa akin binigay ng parents natin eh. So yun yung issue ninyo. So in order to solve that, kasi umiyak na yung kapatid mo, nakipag-negotiate ka na. Ganto na lang, hati na lang tayo, deng. Sabi niya, sabi mo, and then ang ginawa mo, hinati mo, and then binigay mo yung kalahati doon kay kapatid mo. So yun, binigay mo, and then yung isa para sa'yo. So ganun, hating kapatid, di ba? So that is the process of negotiation. So it's the same with the conflict between juridical person and then between another juridical person, okay, or conflict between another company and another company. Okay, ganun lang yung proseso. Mag-uusap sila, and then until such time they meet up or they could find satisfaction on the proposition or decision nilang napag-agrian. And then we have here distributive and then integrative, yung bargaining na sinasabi natin, di ba? In negotiation, we usually bargain, okay? So under distributive bargaining, that is considered as win-lose. Bakit win-loss? Kasi the parties doesn't see the other party as they see the other parties as enemies. Kaaway yung tingin nila sa isa't isa. So anong mangyayari? Gusto nila mas lamang yung makuha nila. So with that, win-lose yung mangyayari. Merong matatalo doon, merong parang talo. Merong lugi, and then meron yung lamang. So unlike in integrative bargaining, dito naman view other parties as their teammates. So yun, win-win. So walang lamang. Okay, parehas lang sila. So win-win solution, 50-50 in other words. So yun, pabor sa akin, pabor din sa'yo. Hindi ka lugi, hindi ako lugi. So ganun dun sa integrative bargaining. Pero sa distributive bargaining, palamangan. Okay? Mas gusto nila lamang yung makuha nila kaysa dun sa other parties. So that is simply negotiation. I hope that is clear. Just take note, in negotiation, it doesn't have third parties. Okay? And then negotiation usually also involves, or it is the methodologies that are being used in hostage crisis. Okay? It's between on the part of the law enforcers and then on the part of the hostage takers. So it relies usually on the ability of the negotiator to get the attention or to get the side of the other party or the hostage takers. So simply, we don't make it as complicated. That is simply the basic explanation on negotiation. So don't forget also the two kinds, distributive and then the integrative bargaining. And then we have here the so-called facilitator. Okay, so facilitator or in facilitation. So facilitator simply just like an instructor also. So he is the one who helps a group of people to work together better, understand their common objectives, just like what we are doing as instructors. So we are also considered as neutral. We are neutral. So in order to help you learn, we just facilitate. We give you activities, we guide you, okay? So, ganun yung parang ginagawa ng facilitator. Initiator, kumbaga. Okay? Nagsisimula or nagbibigay lang ng instruction, and then yun, para hindi kayo mawala, okay? In order na mapunta kayo or matuto kayo. So, facilitation. Facilitator. It's same in dispute resolution. So, yun yung ginagawa niya. So, he facilitate or initiates the meetings or the proceedings between the two parties. So he is considered as the third person in facilitation. And then we have here the qualities. So na-mention dyan, we have here unbiased. So unbiased, hindi, of course, natural, unbiased, or hindi siya, wala siyang pinapanigan. Okay, and then ano pa, the so-called, what is the second quality that a facilitator must have? Safe. Okay, skill to create and maintain a safe environment, or maintain that there is no sabihin natin na violence that is being made. Listens, he knows how to listen. He listens between the two parties, not only on a single party. Structured, he has natural gift of providing structure for discussion, or he is in scheduling or gathering the opinions of those parties, and then he concise. Fearless, questions to challenge. Okay, so fearless, especially kung medyo yung parties are more on medyo mainit, or there is tension, so wag sana siyang matakot during that time. Proactive, kasi yun niya, sabi natin, facilitator should be the initiator. Flexible, okay, he should also be flexible. Connects between the two parties, not only on a single party. So timely, speaks of time management and social. Okay, so he should know how to talk with the parties. So that is under facilitator. So last methods of conflict or dispute resolution is the so-called conflict avoidance. So ito yung usual na ginagawa ng ibang tao na ayaw na nila ng sakit sa ulo. So instead na i-confront nila yung claim ng tao na yun, iniiwasan na lang. So yun, walang mangyayari. It could hindi na masolve yung dispute, so it is considered, or it can be considered as lose strategy. So wala na. Walang mangyayari since ayaw nilang makipag-participate or ayaw niyang i-confront yung issue. So, sometimes also, he always change the subject until such time makalimutan na yung issue. So, anyway, in conflict avoidance, they say also that it could also be the best methods to solve conflict, especially minor conflicts. Okay, especially simpleng away lang, di ba? Ang ginagawa niyo, in order na lang na tumigil na yung issue, sabihin natin yung crush na yan. So yun, sinasabi nila or pinagkakalat nila, crush mo daw si Iskaran, ganito. So mga yun, na issue. So in order na para manahimik na yung mga klase mo, you just avoid. Okay? Iwasan mo na lang para hindi mas lumaki pa yung issue. Kasi kapag sasabihin mo, sabihin natin na tinutokso ka nila na yun, crush mo daw si Iskaran na, balita ko, crush mo daw si Iskaran, mga ganun. And then yun, kapag pinatulan mo, usually lalaki yan, di ba? Kapag naging over defensive siya, so meaning totoo, parang ganun yung mangyari, di ba? Simpleng away lang, so, or simpleng conflict lang, or mga bagay. So in order na hindi pa lumaki yung issue, you just avoid. So sometimes conflict avoidance is also a best strategy in order to solve or to avoid bigger issues. Okay? Or it avoids na yung small issue, it becomes a bigger issue. So that is for conflict avoidance. So we have here also types of conciliers. So ito yung number one, feeling swallowers who we have there the number one, the feeling swallowers who swallow their feelings. So ito lang naman yung mga tao na kahit na deep inside ang sakit-sakit na pero ngiti pa rin. Okay, so parang sa inyo, kahit ang sakit-sakit na sa damdamin ninyo, pero yun, nakuha nyo pa rin ngumiti. Okay, why? So yun, you are not revealing your true feelings. So feeling mo kasi it would be dangerous if you are going to affront your true feelings to them, or makakasakit ka. So the method that you use is just to swallow your feelings, your true feelings. Okay, itago mo na lang. But actually sometimes that is not good. So it's better if you should sometimes reveal your true feelings so that they know also what they should do. Kasi nananahimik ka lang dyan, yun pala hindi pabor sa'yo, pero sa kanila akala nila pabor yun sa'yo. Pero yun, deep inside mo pala hindi pabor yun sa'yo. So at least kapag malaman nila na hindi pala pabor sa'yo yun, then at least they will recommend another, sige, ganito na lang yung gawin natin para at least walang lugi sa atin. Parang ganun ba na situation. So number 2, we have the so-called subject changers who find the real issue too difficult to handle. So they change the topic by finding something on which there can be some agreement with the conflicting party. So sometimes it tends, so yun, binabago-bago yung usapan. Sometimes it tends not to solve the problem actually, but instead it create problems for the people who use this and for organization in which such people are working. So it can create a bigger or another conflict. Okay, so simply that non-cooperation in solving the real issue. Okay, gumagawa ng ibang issue. Okay, so that is number 2. And number 3, the so-called avoiders who go out of their way to avoid conflict. So simply yung mga nagwo-walk out na. Okay, so wala nang pakialam. So those are the 3 types of conciliers as we have there in your notes or in our PowerPoint presentation. Next one is the so-called we are going to talk on the 2 major types of dispute resolution. Number 1, there is the adjudicative processes. So in adjudicative processes, simply it involves litigation or arbitration. So meron tayo dito yung mga tinatawag na judge, jury, or arbitrator. So meaning they have the power to give decisions or arbitral awards. So unlike in consensual processes, walang kakayahan or walang nagbibigay ng decision. So simply consensual. So kapag nag-agreean nung dalawang party, then that's the time the decision will, or the proposal or the recommendation or the recommended solution will be only implemented. So unlike in adjudicative processes, the jury or the arbitrator, they can determine the outcome and then they could give a decision or sentence or an arbitral award. So there it is considered as a legal ruling or judgment. So that is adjudicative process. Second one is the consensual process. So dyan, an example of that is the collaborative law, mediation, conciliation, or negotiation. So the parties attempt to reach an agreement, so consensual or agreement between them, and all parties are in agreement that they approve of it. So parang majority wins. Okay, majority shall be followed. So those are the 2 types of dispute resolution processes. Okay, next we are going to talk about the Philippine International Center for Conflict Resolution or the so-called PICCCR. So hindi po PCCR ha, PICCCR. So PICCCR, don't forget what does it stands for. Okay, so PICCCR is under actually ng Integrated Bar of the Philippines. Okay? So, sino ba yung mga nandito sa bar? Member ng mga Philippine bar. So, usually yung mga bar passers. Yung mga nakapasa sa bar exams. Okay? Mga lawyers, in other words. So, Integrated Bar or IBP, ito ay under ng they are under this organization. So PICCCR is considered to be a non-stock, non-profit arbitral institution that will provide commercial arbitration and other alternative dispute resolution services facilities. So it's not only arbitration process but also it could be mediation process. So this organization, they promotes the ADR. Okay? So ito yung isa sa mission na madidiscuss natin or the goals of this organization as we go on with our session. Okay, and then this organization also helps in making the arbitration more accessible and a mainstream option for dispute resolution in the Philippines, kasi they are also providing trainings for the in preparing those people who wants to practice as an arbiter or join an arbitral tribunal in order to solve disputes, okay, or in the process of conflict resolution or dispute resolution. So yun, aside from that, they also provide arbitration related facilities administrative or case management services, high quality education and training for interested arbitrators. So yun yung, as I've mentioned a while ago, they provide trainings also for those who would be or who wannabes arbitrators. Intensive promotion and marketing events, promotes ADR actually. So the headquarters of this PICCR is in IBP main office, or the Integrated Bar of the Philippines main office in Ortegas, Metro Manila also. So yun, in education and training, they provide intensive training again, as we have mentioned a while ago. They also conduct workshops for those who would be or wannabe arbitrators. Okay? So they give workshops in order to train them. So sa workshops, of course, parang mga situational yung ibibigay dyan. So anong gagawin mo pag ganito yung situation? Merong conflicts na nailapit sa'yo, anong gagawin mo as administrator? So yun, usually kinakandak nila in workshops. Center is in its early stage of selecting qualified individual to join a panel of trainers for courses. So they prepare those persons who want to be in the practice of arbitration. Okay? And then meron tayo dyan yung modules. So ano ba yung modules na meron sila, or the parang courses na meron sila? It is composed of 3 modules daw. So module 1 on fundamentals of commercial arbitration. So actually in commercial arbitration meron tayo yung batas niyan. So we will be discussing that later on our next topics. And then second one, we have here the PICCR arbitration rules, which will be discussed later on. And then it's in their in their website actually. Meron sila diyan. So if you have some time, you can just search on those arbitration rules that they have. And it is also included in some of the sessions or statements under the law on our Philippine arbitration. And then we have here the third one, module 3, writing arbitral awards. Okay, so as we have mentioned the last time, arbitrators, they can issue arbitral awards or decisions. So in this course, the participants will undergo assessment during each of these modules, so they will have examinations also. And then ensure that accredited arbitrators will have the necessary knowledge, skills, and expertise. Syempre, kasi they are also considered as judge, somewhat like a judge, di ba? So they should also be that skillful para hindi mali-mali yung decision na maibigay nila. Kawawa naman yung parties na mabibigyan nila ng decision na unfair or decision na mali. So, ang magsasuffer doon is yung clients nila. So, here we have the promotion of arbitration and ADR is one of the goal of this organization. So, that's it. Regularly collaborate. So, the PICCR, they are in teamwork with IBP activities and events. With that, we have here the chairman of the Board of Trustees, Mr. Abdiel Dan Elijah S. Fardo. So, kindly take note of that. Baka lumabas sa inyong quizzes. Okay? So, he is the chairman or the current chairman of the Board of Trustees. And then we have here the composition of the Board of Trustees. So, they are composed of 7 members. Okay? 7 trustees elected by PICCR members. So, it is composed of 7 trustees. And then, doon sa yung 7 na yun na trustees, they will hold the office for 2 years. And then, 5 out of the 7 trustees will be elected from the incumbent IBP Board of Governors. So, manggagaling sa IBP or manggagaling sa Integrated Bar of the Philippines Board of Governors. And then, yung dalawa manggagaling sa elected members, or it will come from the members of the center or manggagaling mismo sa PICCR. Okay, and then the operations of the center as an arbitral institution will be supervised by the president. So meron yung president kasi ng PICCR. Okay, so he is the one who will be supervising the board of trustees, and then it shall be carried out also by the Secretary General, or the President will be supervising the PICCR itself as a whole, and then the Secretary General will carry out the orders coming from the president of the PICCR. So as to the current president, it is he is Mr. Sixto Jose C. Antonio. And then the Secretary General, kindly please take note also, Don Mark Joseph L. Calimon. So they are the key officials of the PICCR. And then the vision is to contribute significantly to the improvement of the administration of justice by promoting the use of arbitration, as we have mentioned a while ago. And then the mission is to promote the use of arbitration. It is somewhat same again with their vision. It is somewhat connected, I should say, in their vision. And raise awareness of the benefits of arbitration. Kasi na-mention natin kanina yung mga advantages ng arbitration. Yun yung pinopromote din nila, the PICCR. Pinapakita nila the advantages of the arbitration in order for them to avail or to choose arbitration as the method of dispute resolution para maiwasan na yung hectic na schedule or tambak na kaso doon sa korte natin. Okay, and to provide intensive for those or yung trainings para doon sa mga would-be arbitrators natin. So that is their mission. And then we have here the PICCR pen or yung logo nila. The centerpiece of the PICCR is yung PICCR logo is they have the centerpiece as the pen, yung pen. Makikita ninyo sa presentation natin. And then it also represents the power of the pen represents the power or the way na sinentralize nila is to represent the power of the pen. So the power of reason or and the availability of the alternative and amicable means to resolve disputes. So yun nga kasi merong kakayahan din we can solve disputes outside court. Not only the courts has the power to solve conflicts, but also it can be solved by us itself and then with the help of arbitrators or mediators. The gray color of the pen symbolizes impartiality and independence. The two circles resting on the two triangles, it symbolizes the parties symbolizes the parties to the dispute. And then the bigger gray circle on top of the pen tips stands for the arbitrator or neutral. Okay, so yun, it symbolizes that the arbitrator is neutral. What else? The world map, so yung sa background, inside the oval represents the domestic and international trust of the PICCR. Kasi we can also, meron yung tinatawag natin na commercial arbitration. We can also solve conflicts even though that it is outside. Okay? So, kasi meron yung mga business or mga companies natin na multinational, di ba? Or international companies. So, actually, meron din tayong international companies. So, with that, conflict existing with that could be helped or could be penetrated or it could go with the PICCR. Okay? So, another one, the oval shape in purple color that circumscribe the centerpiece and contain the full name of PICCR represents the violation or relationship between the PICCR and the IBP. So it's not a violation, sorry for that. It is a relationship between PICCR and the IBP. So with that, please don't forget those symbols or meanings of the pen or the logo of the PICCR. And that also ends our chapter 1. So I do hope that you have learned something on those discussions or in these video recordings that we are uploading. So if you have a question again, kindly please don't be shy to ask it or have it in our comment section, or if not, you can raise it when we are going to have our synchronous session so we can discuss it as a class. So that ends our chapter 1. Thank you once again for watching this video recording.